Washington state just passed a 9.9% income tax. And almost immediately, two separate challenges emerged. First, a constitutional lawsuit aimed at striking the law down in court. Second, a referendum effort designed to put the tax directly to voters and potentially repeal it at the ballot. So this isn't just one legal battle. It's a two-front fight, courts and voters. And both matter for how this ultimately plays out. Let's start with the lawsuit, because that's where the core constitutional arguments are being tested. The challengers are serious. Rob McKenna, former WA Attorney General, is lead counsel, and former WA Supreme Court Justice Phil Talmadge is involved. Groups like the Ethnic Chamber of Commerce Coalition, BIAW, and NFIB have signed on. Now, the part the news doesn't explain well. Governor Ferguson and the legislators know the constitutional argument and passed it anyway. Senate Majority Leader Jamie Pedersen said the legal challenge is expected and welcomed. Why? Because if they win in court, if the WA Supreme Court says income is not property, that changes the tax landscape permanently and opens the door to broader income taxes. Timeline. Case starts in Klickitat County Superior Court. Talmadge has said they'll push to skip the Court of Appeals and go directly to the Supreme Court, potentially by early 2027. A referendum attempt was blocked because the bill was designated necessary for the support of state government. A citizen initiative is possible, but the constitutional lawsuit is the primary battlefield. Here's what I tell clients. First, don't assume this will be struck down. Plan as if it holds. Waiting until the end usually means you're too late. Second, if you're considering a domicile change, that clock starts now. WA domicile changes aren't a December 2028 paper shuffle. You need real-life changes and documentation. Third, equity structures matter. If you're a founder with significant equity, QSBS, safes, convertible notes, the structure you put in place now can shield a meaningful portion of your exit, even if the tax survives. But you must do it before the gain-triggering events. Fourth, your business structure may need a review. PTE elections, S-Corp versus C-Corp decisions. Those need to be made and implemented well before 2029. I'll be watching this case closely, and we'll be back with material developments. Make sure you're subscribed so you don't miss it. And if you want to talk through what this means for your specific situation, equity structure, business exit plan, book a 20-minute call with me. No obligation, just a conversation. The only question left is, what will your plan say?